We will talk more about the Affordable Care Act, and there's actually a specific session for this, and it coincides with Chapter 13 when we talk about health policy. But the main thing that the Affordable Care Act did in terms of hospitals is that it had a provision that no new physician-owned hospitals can be opened, and whatever physician-owned hospitals that were already in operation cannot be expanded. Now, going back to lesson 1, we talked about how hospitals primarily started in the United States, especially the private ones, as the for-profit hospitals that were owned by physicians. The ACA also, the Affordable Care Act, also required that nonprofit hospitals must assess community health needs, and they should have plans in place to meet those needs. So a lot of nonprofit hospitals have actually formed departments that are geared towards assessment of population health, and then they also come up with programs, health education programs, health promotion programs that deal with the health needs of the community that they serve. Remember, in lesson 3 we said that nonprofit hospitals, private nonprofit hospitals, have an obligation to the community that it serves. It also required, the Affordable Care Act also required that nonprofit hospitals must have written financial assistance policies, and there are certain limitations on what actions they can take in terms of collecting hospital bills, but these also are meant to certain groups of patients. So this time let's talk about licensure, certification, and accreditation of hospitals in the United States. Licensure is granted by the state, so it's the state health department that provides licensure for healthcare facilities to operate. And licensure is a legal requirement to operate a hospital, meaning you're breaking the law if you don't have a license given by the State Department of Health. It requires compliance with state laws, building codes, fire safety, and sanitation standards. Now, there are federal, state, and local ordinances for this, but fire safety is considered to be a federal level requirement. Now, let's talk about certification. Now, certification is granted by the federal government through the Medicaid and Medicare program, and it's essential for any hospital to be able to see patients that have Medicaid and Medicare to have the certification. And to get the certification, a hospital must be able to prove that they satisfy the conditions for participation, such as compliance with the standards that are required by the federal government through Commission on Medicaid and Medicare services. Accreditation, on the other hand, is granted by private entities such as the Joint Commission, also the National Council for Quality Assurance, NCQA. We have referred to them in past lessons. This is voluntary, and to get this you must satisfy the standards. And getting an accreditation is a deemed status. So the organization basically confers to the hospital a deemed status of being accredited. And an accredited hospital is deemed to have met Medicare conditions of participation, meaning if you've passed this, that means you have also passed the Medicare certification. Now, while we say that accreditation and certification are both voluntary, it's really not feasible in this current environment not to have both. So legally speaking, what you're really just required is to have a license. However, for practicality's sake, you can't really operate a hospital without certification and accreditation, because for certification that's needed for Medicaid and Medicare, and accreditation, that's what private health insurance companies look for before they consider reimbursement for the services that you have provided. Now let's go to hospital organization. So a hospital is responsible to a lot of stakeholders, and stakeholders are any entity that has an interest in the operation of the hospitals. And this could be the community, the government, health insurance companies, managed care organizations, and of course accreditation industries. Hospital organization consists of the board, the chief executive officer, and the medical staff. The CEO basically receives delegated authority from the board, and the CEO is responsible for managing the hospital. Now, the medical staff is headed by the chief of staff, also known as chief medical officer, and that is the clinical aspect. As I've mentioned before, because of the way hospitals operate now as integrated delivery systems, the person at the helm, who is the chief executive officer, must have experience and knowledge on both clinical, administrative / financial side of operating a healthcare facility. Thus, most chief executive officers of huge integrated delivery systems are themselves physicians that have acquired skills and training in terms of hospital administration. Now, the physicians are generally not employees of the hospitals, but are affiliated with the hospital by admitting privilege conferred on them by the hospital. These are the physicians that have independent clinics outside of the hospital. We're talking about ambulatory care, but the hospital itself, of course, has its own house staff, which is headed by the chief of staff. And the house staff, the physicians in staff, are employed by the hospital. Now, let's discuss ethical issues and ethical challenges in healthcare delivery. So just to give a brief background, physicians and other caregivers are expected to have moral responsibilities when they deliver clinical care. They are guided by ethical principles, also known as beneficence or non-maleficence. And beneficence is a health service organization. It means that a health service organization has an ethical obligation to do all it can to alleviate suffering caused by ill health and injury being experienced by patients. Non-maleficence refers to health services personnel, and they do have a moral obligation not to harm patients. So no less challenging is the ethical issue surrounding the definition of extraordinary or what we call heroic measures to sustain a person's life. So we're talking about life-saving machines or life-sustaining machines such as ventilators. When physicians do this, they must follow their own consciences. They also have to apply personal ethical values. They have to follow hospital policy and hold all patient information in strict confidence. Legal ethical standards require that the patient's consent before treatment is rendered. So that's on the part of the patient. Discussion of the various treatment alternatives, what is there available, and the outcome as proven by science. And then patients' participation in decision making and the selection of treatment options is also key. And of course, last but not the least, healthcare facilities, hospitals, and physicians are expected to practice fairness, equality, and non-discriminatory practices. Now let's talk about the Patient Self-Determination Act of 1990. So interdisciplinary ethics committees deal with these complex issues, and The Patient Self-Determination Act of 1990 applies to all facilities participating in Medicare or Medicaid. And it basically refers to patients' rights. First is informed consent. On the part of the patient, he or she needs to be informed of the treatment choices and to make an informed choice, including the choice to refuse treatment. Now, informed choice basically means that the patient has been fully briefed, in whatever way possible to make the patient understand about the treatment, and therefore he or she should be able to make an informed choice in terms of receiving the treatment or not. It is a basic patient right, and that is enshrined through the Patient Self-Determination Act of 1990. Now let's talk a little bit about advance directives. So advance directives allow patients to express their wishes regarding continuation or withdrawal of treatment. So there are three types of advanced directives. First is power of attorney. This basically authorizes the person to designate a person, giving the person the power of attorney to make financial decisions. And this is done through licensed counselors or people that are attorneys. It cannot be used to make healthcare decisions. Now, living will is a document that you will sign in advance in which you specifically set forth your decisions about healthcare treatment. It, however, does not authorize you to appoint an agent to make decisions for you in case, something happens wherein you're still alive, but you do not have the mental capacity to make that decision. So it falls short of what is really necessary to cover all your bases, so to speak. So the third one takes care of this, and it's called healthcare proxy. Now, New York State is a healthcare proxy state, and in the state of New York, healthcare proxy supersedes any type of advance directives. So if you have a legally and well filled out healthcare proxy, if you follow all the instructions, it supersedes any type of advance directives that we have mentioned, that we have talked about before. So under New York's healthcare proxy law, any competent person can authorize another person. It could be a family member or a friend, and that person is then authorized by the other person to make healthcare decisions only if the patient becomes unable to do so. And you do this by completing a healthcare proxy form. Now, towards the bottom of this session, there is actually a link for the New York State healthcare proxy form. So I encourage you guys to take a look at it, download it. There are actually 2 videos as well that follow through after this lecture video, which explains even more in detail the importance of advance directives and specifically having a healthcare proxy. So healthcare proxy is applicable to all of us, 18 years old and above, because anything can happen. But there's a more scrutiny and more attention given to healthcare proxy for people who are older because of end-of-life issues. So just to conclude the entire session, any facility that treats patients on the basis of an overnight stay is called an inpatient facility. So this includes hospitals and as well as long-term care facilities, which we will be discussing in the next session. Both long-term care facilities and hospitals are originate from almshouses, as we have talked in lesson 1 of chapter 8. Also, historically, the way hospitals have expanded and contracted is because of policies that came from the government. So health policy, we're going to talk about health policy towards the end of the semester. And also, Obamacare, the Affordable Care Act, is a perfect example for that. And it has imposed restrictions on the expansion of physician-owned hospitals. And also, last but not the least, is that the majority of hospitals in the United States are community hospitals. So this ends this entire session. I encourage you to go through all the videos because there will be questions from those videos in the quiz, as well as in the final or the last exam you have for the semester, exam 3.